I'll be speaking, Professor Kelso will be speaking, and a person from FIRE. FIRE is a group that litigates free speech issues on campus. I strongly encourage you to attend. It's on at 11 o'clock on Thursday. Torchy's Tacos will be served. I'm sure that's a far bigger draw than me. Good reason, I suppose. But I encourage you to discuss, and particularly the steps that various colleges are taking. Can we start? Thank you. The steps that various colleges are taking to censor speech is very, very troubling. I'm grateful that I don't see it at South Texas in the least, but some of my friends at other schools are not so fortunate. So that's Thursday at 11, basically immediately before this class. So you'll see me for 4 hours straight, or whatever it happens to be. Okay. Questions on last class? Questions on Roe, on Eisenstadt, on Casey? Anything on your minds? No? Wow, must be really easy to understand cases. Okay, very good. I'll move on. Our discussion today focuses on what was formerly known as the gay rights trilogy, although of course now it's a quartet. But for many years, or at least for the first few years I was teaching, these were the three major cases in the court's gay rights jurisprudence. So my goal for class today is twofold. So first, I want you to understand the development of doctrine. What do I mean by that? We spent the past several weeks discussing equal protection and due process. We've discussed tiers of scrutiny. If you're a suspect class, you get strict scrutiny. If you're a quasi-suspect class, you get intermediate scrutiny. If you're some non-suspect class, you get rational basis. With respect to substantive due process, fundamental rights get strict scrutiny, and non-fundamental rights get the shaft. Okay? The cases we start doing today and into class on Thursday. By the way, the reading for Thursday is long. If you haven't started, start now. It's going to be the longest of the semester. You're going to have to read the entire Bergefell decision. So read it. Don't slack. All the opinions are important. But the development of doctrine from Romer to Lawrence to Windsor and then to a Bergefell for next class chucks out the window everything you've been painstakingly studying for the past few weeks. I tell this to students because I want you to understand the body of constitutional law is in no respect fixed. Even doctrines that were taught for generations of law students about tiers of scrutiny and fundamental rights don't have much weight. And one of the most frustrating aspects of teaching these cases is the inevitable student saying, but wait a minute, what's the tier of scrutiny here? And well, is this a fundamental right? And my answer to you is ask Justice Kennedy. But my better answer is Justice Kennedy doesn't particularly care. And this is the overarching goal. Since Justice Kennedy has been on the court, he has been more or less in the center of almost every major constitutional dispute. It's good to be the king. He doesn't particularly care for labels like scrutiny. He doesn't care for things such as fundamental rights. What matters to him are phrases that are foreign to our constitutional law, such as dignity, the dignity of the person. You don't want to demean someone's existence, right? He has basically built up without any, without any path, a body of constitutional law that is very difficult to grasp. So what I'm going to try to teach you today, and I probably won't succeed because it's some of the tougher cases to teach, is how this doctrine evolves. Okay. The second element of how I want to run this class and next class is a discussion of the actual social issues behind these. The Supreme Court does not operate in a vacuum. Although they have life tenure and they're not held for election, they exist in the world they find themselves in. And Justice Kennedy's opinions, perhaps you can call them incremental, reflect a growing acceptance and awareness of gay rights, from Romer to Lawrence to Windsor, and then on to Obergefell. In fact, his decisions make explicit reference to this trend, this growing awareness. So for Kennedy, the fact that society as a whole is gaining certain acceptance, granting of gay rights, whatever else, civil partnerships, whatever they want to call them back then, that informs his constitutional discourse. Okay? Contrary-wise, which is a word, I promise, contrary-wise, Justice Scalia's dissent in these cases I've characterized as a 2-decade cat-and-mouse game, where it seems that you always have Nino nipping at Tony's heels, yet at no juncture does Justice Kennedy ever bother replying to any of the criticisms. That's another thing that Kennedy drives me nuts. He never, ever, ever bothers replying to any criticisms in the dissent. He just ignores them because it's good to be the king. The extent of that is Scalia's comments don't go addressed. The final note I want to address, and this is something which perhaps is all the more salient in light of Justice Scalia's passing about a month and a half ago, reflects the ways he talks, his language, right, his tone. No doubt, some people may be offended by the way Justice Scalia writes his dissents in these cases and others. Too bad you have to read them, but no doubt people find them offensive. And indeed, in one of the leading ConLaw books, which I do not assign, the author, the editor, Chemerinsky, has decided to not include Justice Scalia's dissent in the Obergefell case because it was too hateful. That's a mistake, and I can teach an entire class of why that's a mistake. But I want you to understand about Justice Scalia's dissents, and I think this comes through more so in the later ones than the earlier ones, is that he's trying to articulate a theory of democracy. Okay? He's not casting his aspersions on any particular group. He says explicitly, if various groups are able to seek change to the democratic process, they can so do. He adds, within our existing framework, unlike race, which is what has strict scrutiny been afforded, the court never bothers providing the sort of scrutiny or the reinforcement necessary. So, although Scalia's language, no doubt, can be read as being harsh, like most of his dissents, not just in civil rights cases, he uses that language to promote effect, to suggest and make an impact on the reader. He goes without saying that his language was not always effective. And in cases involving abortion, like the Webster case I mentioned last week, it almost backfired and alienated people. So whether or not Scalia's dissents had the impact he sought, I at least will try to give you the frame of where he was coming from. So those are my 3 goals for today, at least. Describe the development of the doctrine, to discuss how this doctrine fits with a broader social consequence, and to address in some part the way that these opinions will be read at some point in the future, which no doubt I think inspired at least the majority opinion to use such lofty language. Okay. Any questions before I get started? Yeah.
What was the third one after fitting the doctrine?
Oh man, I spent 5 minutes talking about it. Trying to view how these decisions will be viewed later. Yeah, I appreciate the repetition, but okay. Okay, let's start. So our discussion today actually begins with a case I didn't assign. And again, I wish I had more credits for ConLaw. I would have broken this up to 2 classes, but I don't have enough hours, so I have to put them all in one. The case was 1986, Bowers against Hardwick. This case involved a Georgia ban on sodomy. What is sodomy? Okay, simply stated, sodomy is non-vaginal sexual intercourse. There, I said it, right? Oral, anal, whatever you want to call it, it's non-vaginal. For much of recorded history, if you read your scripture, sodomy was viewed as sinful. And most states had laws prohibiting sodomy, one of which was Georgia. So the Georgia case begins in 1982, where the police are executing a warrant to pick up a guy who didn't appear for a court hearing for drinking or something stupid, and they opened the door and they found that there were these two guys engaging in oral sex. So they arrested him and they charged him. And in 1986, this case goes to the Supreme Court. And the Supreme Court rejects the defense of the defendant. And they say, look, gays and lesbians, right? The classification on this basis, this is not suspect. This is not like race or religion. So we afford rational basis review. With respect to the due process clause, is there a liberty interest engaging in sodomy? And the court says absolutely not. Absolutely not. Indeed, if you actually read the court's jurisprudence on marital privacy, it's connected to procreation, right? The reason why husband and wife have this sort of marital privacy in Griswold and otherwise is to procreate. Sodomy, in no respects, can lead to reproduction. It simply can't. Biologically impossible. And then finally, the court held that the state has a legitimate state interest in legislating morality. Now, when I say this, students are like, what do you mean legislating morality? Most of the laws we have on the books are based in some sense of morality. Some are religious, some of it cultural, or whatever you have. Laws against prostitution, certain minors drinking alcohol, go up and down the list. A lot of our laws are based in the sense of, oh, he shouldn't do that. Laws against heroin use, oh, he shouldn't do that, that's bad, right? Some of it stems from religion, some of it stems from common law, whatever you want to call it. But the court says that moral disapproval, right? Just saying we disapprove of sodomy, that's a legitimate basis on which a state can rule. I realize when I say this to most millennials, it's like, what do you mean moral? Well, for most of Western civilization, in fact, the first 200-odd years of our republic, this is how laws were passed. I guess we only have our sense of frame when we start paying attention, but this is a long-standing tradition of how laws were enacted. And the court said, we've had sodomy laws for 200 years. How can this possibly be unconstitutional? One of the interesting parts of the opinion is that the judge, I can't remember if he wrote it or he joined, but one of the judges, the majority, I'm drawing a blank at the moment, was Justice Lewis Powell. Powell was always in the middle. He was actually replaced by Kennedy. And there's a report that Powell was talking with one of his law clerks, and he said to his law clerk, I don't think I've ever met a gay person. I don't know any gay people. It turns out that the clerk was gay, closeted, but gay. And when all these cases were coming to the court, he wrote about this. It was like a big, everyone knew, who knew the guy, but the justice never knew. So it's an interesting statement that the justice, I don't know people who are gay, and his law clerk seeing there happened to be gay. But in any event, the court rules against them in 1986 that there's just no fundamental liberty interest to engage in sodomy. If the state wants to criminalize this, they can. Now, what happens after this with respect to sodomy is interesting. Unsurprisingly, these laws are not enforced. Okay. Why are these laws not enforced? How do I put this gently? It's really hard to catch people in the act of engaging in sex, right? Generally speaking, people are engaging in sexual relations in a closed room where the police have no right to be. Now, in the rare case that maybe the police are executing a no-knock warrant and they catch them in the act, I suppose it happens. But for the most part, these laws were never enforced, ever, until we get to Lawrence, which we'll talk about in about 20 minutes. But these laws are just never enforced. So opportunities didn't really even arrive to test these in court. Even though states are repealing them, those states that left them in the book simply, there was no enforcement of them. Okay. Indeed, a lot of states, not a lot, I think 3 or 4 states, even today in 2016, still have sodomy laws in the books. They're never enforced, so there's no chance to strike them down, and until the legislature votes, they stay there. Okay. So in 1986, we have Romer, right? And then in 91 or 92, we have Casey. And you remember how Casey had this strong, passionate defense of stare decisis. as they say, liberty finds no refuge in a jurisprudence of doubt. That, precedents that have been around for, 19 years are so important that people rely on them that we can't uproot this Roe v. Wade case. We'll just rewrite it. But we can't say we're overturning it because precedent is so important. We'll look like fools if in the span of, 19 years we change our mind on issues divisive as abortion, right? Everyone remember this, right? And of course, the Kennedy, O'Connor, Souter triad wrote the plurality in Planned Parenthood versus Casey. That brings us, for our purposes, to 1996 with the case of Romer against Evans. Where did I finish last time? Come on, someone has to raise their hand. You pointing at her?
Well, Laura just went.
Yeah, I went last.
Robin, you're next?
Sure.
Okay, thank you, Robin. Yeah, throw her under the bus, huh? So, do you want to tell me, Robin, describe Amendment 2 in Colorado. What exactly did Amendment 2 in Colorado accomplish?
It repealed any laws that protected gays and lesbians from discrimination based on sexual orientation.
Okay, now, who or which governments were enacting these sorts of discrimination, and not discrimination, but these sorts of laws that afforded special protections to gays and lesbians? Which governments?
The states, so different.
Not the states. Which level of government were instituting these laws?
Wasn't it different? I feel like multiple cities.
Cities, exactly.
Okay.
Bingo. Okay, so here's what happened. Various cities, and indeed I'll say liberal progressive cities like Aspen, Boulder, and Denver, right? These cities started passing various ordinances that prohibited discrimination against gays and lesbians on the basis of their sexual orientation. As well, these various cities started affording things like, for government workers, health insurance. So for example, if gay couples living together and they couldn't get married under law, various local governments said, okay, we'll give you health insurance because you're domestic partners, or however you want to describe it. The people of Colorado, and that is people outside these liberal enclaves, did not like these laws. And they said, okay, how do we prevent these local municipalities, these cities, from doing something that we don't like? So they decided to enact a state constitutional amendment, which became known as Amendment 2. Like in Texas, you go to the ballot box and you can actually vote on amendments to the state constitution. And as Robin correctly noted, the effect of the amendment was to prevent local municipalities, prevent cities and whatever counties from taking any sort of action to protect gays and lesbians. Okay? Everyone get what the amendment actually did, because there's actually a very vigorous dispute between Scalia and Kennedy. But at a minimum, like objectively speaking, it prevented Denver and Boulder from enacting these sorts of laws which afforded various protections to gays and lesbians. Beyond that, they're going to argue, but everyone get the basis, right? Yeah. So this is challenged in court, okay? This is challenged in court. So let's see. Katie, so if you were a lawyer for the challengers and you were there in 1995, whatever year this began, what do you think would be your best argument about why this Amendment 2 is unconstitutional? What do you think you would argue if you were the lawyer?
Equal protection.
Okay, good. What would the equal protection argument be?
Basically that there's still people who should be protected just like anybody else, just because they're somebody who's the same gender doesn't mean that they should be discriminated.
Now, fit this into the constitutional doctrine that I've been teaching you for the past couple of weeks. What would the doctrine be here? How do we go about doing an equal protection case?
The equal protection cases that we're looking at, like, look at the different scrutiny levels.
Okay, how do we determine the various scrutiny levels?
Basically, it's like the type of class that they are.
Okay, so if it's a racial or religious classification, we do.
You do like the lowest and work up, but they're not a suspect class.
Ah. So sexual orientation is not a suspect class, right? So it gets what kind of scrutiny?
That would be be strict scrutiny if it was suspect, but it's not, so they go down to like rational.
Beautiful. Perfect answer, right? So if you're a lawyer for the, challengers in this case in 1995, you say, well, wouldn't it be awesome if gays and lesbians were given strict scrutiny? Well, they're not. And indeed, Sarah, what case do you have that has been decided recently which makes it clear that you don't give heightened scrutiny to gays and lesbians? Which case?
That we covered?
Yeah. I talked about 5 minutes ago. I spent 5 minutes talking about it. Remember I said the case is not in your notes, but I'll tell you about it.
Oh, yeah. Georgia.
Yeah. What was that case about? Bowers v. Hardwick. Yes. Bowers v. Hardwick, the Georgia case I talked about a few minutes ago. That held quite clearly that gays were not a suspect class, and it held quite clearly that sodomy was not a fundamental right. So it would seem that the case of the challengers is somewhat difficult, right? There's a Supreme Court case, Bowers, decided not even 10 years earlier, that's directly on point in the other direction. Okay, so this case goes to the Supreme Court of Colorado. And interestingly, the Supreme Court of Colorado ignores Bowers. They say that gays and lesbians are a suspect class, notwithstanding Bowers, and they're subject to strict scrutiny. Okay? Now, other Sarah. I'm sorry. One Sarah, two Ashleys. I'll get it eventually. Ashley, could the Supreme Court in this case have said, you know what? We agree with the Colorado Supreme Court. We're going to overturn Bowers. Could they have done that?
Could the Supreme Court?
Yeah, could the Supreme Court have said, you know what? Bowers was a mistake. We were wrong. Strict scrutiny for gays and lesbians. Could they have done that? What a good answer. What a good answer. Not even 5 years earlier, the court had this beautiful, majestic, they built like a statue to stare decisis. Said we need to stand by our precedents, right? We need to stand by our precedents. So Ashley's exactly right. The court could have just said, you know what? Let's make this easy. Let's just cut to the freaking chase already, right? Give gays strict scrutiny and be done with this entire, Amendment 2 business. They could have done that, right, Ashley? Okay. Now, Ashley C., what would have been the consequence, though, beyond stare decisis? What would have been the consequence in 1996 to say that all classifications on the basis of sexual orientation are subject to strict scrutiny? What would have been the consequence of that statement? How would that have affected our society? When a very, very radical change, but how would it affect our society? Let me ask the question a different way. What kind of lawsuits would have been brought after the court established that strict scrutiny is appropriate? What kind of lawsuits would be brought? What's the biggie? What's the big one I'm talking about? What's the biggie? If the court held that classification on the basis of sexual orientation are subject to strict scrutiny, what's the biggie, the big lawsuit that would be brought? What's the big one I'm talking about? What's a reading for Thursday? What's the big one? Yes. Imagine if in 1996, the court held that classifications on the basis of sexual orientation are given strict scrutiny. Boom, marriage laws are done. The next day, not even the next day, 5 minutes later, the ACLU would have been federal court suing, saying, hey, strict scrutiny, we got this opinion. Gay marriage laws can't stand. Everyone understand that, right? This is why I call this incrementalism, but it's not really. I'll get you a second, Adelaide. Had the court held in 96 that strict scrutiny was warranted, the ball game was over, right? This entire 20-year process from Lawrence to Obergefell, just cut to the chase, right? Just cut to the chase. What do you think would happen, Luis? I'm sorry, Natalie, I skipped over you. I'll come back to you. Yes, ma'am.
I'm sorry. Did you say that
If the court said strict scrutiny is appropriate, then laws supporting gay marriage would have fallen very quickly.
I mean, not so simply because a class is able to be or to bring a case under strict scrutiny doesn't necessarily mean that they would have been overturned, right?
What did I tell you about strict scrutiny? The government always wins. I'm sorry, the government always loses. Sorry, I reversed my head. With strict scrutiny, the government loses. The only classifications ever upheld under strict scrutiny were in affirmative action with the Grutter cases. Okay? And you can be sure that lower court judges would say, oh, strict scrutiny applies. That means these laws cannot stand. Luis, let me ask you this question. What do you think would have happened in 1996 if the Supreme Court held that strict scrutiny is afforded to sexual orientation and logically marriage laws have to fall? What do you think would have happened? So what do you think would have happened? Oh, no, I'm talking legally. What would have happened if the Supreme Court says marriage laws cannot stand? What would have happened in 1996? Yeah, say the very next year after Romer, the court said, okay, you know what? We're applying strict scrutiny. Texas's marriage laws have to fall. Yeah, and then what? And then what would the response have been to such a decision?
You're not following the stare decisis.
I'm sorry?
You're not following the stare decisis.
Yeah, screw stare decisis, Kennedy rules, right? What happens after that? I have a very specific answer I'm thinking of. Luis, want to try it?
I don't know the specific answer, but I'm assuming states would try to impeach.
Well, there's impeachment, but what else? Short of impeachment, what else have we done?
Sue somehow the challenge.
What are the people allowed to do in the Supreme Court says they don't like?
Amend.
Amend. This is probably before your times, but there was a legitimate movement in the early 90s, in the mid to early 90s, to have a federal marriage amendment. To amend the Constitution. What was that, John?
I was looking, I didn't know that Supreme Court justices could be impeached.
Oh, they sure can. They sure can. Anyone can be impeached. There was a strong movement in the mid-90s to enact a law, I'm sorry, an amendment to restrict marriage to a man and a woman. I mean, this is not a joke. I mean, this was a legitimate movement to get this across. The history and what was alluded to in the Windsor case, but I'll mention here, is that I think it was Hawaii. The Hawaii Supreme Court ruled as a matter of its state's constitution, the state had to afford was effectively a domestic partnership to gays and lesbians. And then some other state courts started moving that direction, right? These courts are just, reading their own state constitutions however they want. And people were afraid, okay, what happens if a couple gets married in Hawaii and then comes back to Texas? Under the full faith and credit clause, Texas would be obligated to give recognition to that Hawaii gay marriage. This is what led to DOMA, the Defense of Marriage Act. I realize I'm going out of order, but we live in a history that's chronological, not in the pages of your book. The impetus for DOMA was that state courts were starting to find recognition for gay marriage. Not state legislatures, state courts, very different. The purpose of the Defense of Marriage Act was twofold. First, to define as a matter of federal law that for any federal benefits, Social Security, veterans, whatever else, marriage is between a man and a woman. The second effect of DOMA was to ensure that no state was forced to recognize a foreign gay marriage. And this was part of the full faith and credit clause, which I won't talk about, but you'll learn about in other classes. Okay? So these were the two elements. I'll get you in a second. Okay? These are the two elements. In case, for those with short memories, DOMA was signed into law by President Clinton with Democratic Congresses backing it. It was almost a unanimous vote. It was a pretty overwhelming vote. Interestingly, when Windsor came before the court, former President Clinton said the reason why he signed it was because he was afraid of this constitutional amendment. There's no evidence this ever happened. In fact, people have actually looked at the archives, and there was no evidence the Clinton White House was afraid of an amendment. In fact, they actually supported this bill. They, until recently, politicians didn't support gay marriage. It's only happened the last 3-4 years. I suppose if you haven't gone with it, you're not with the times. But this was enacted for the specific purpose of not altering federal law. Okay. Shelby, yes, ma'am. Glad that worked out. I love when things work out like that. Right. So what you have to understand, and this is, how do we put this? This is legal realism at its finest, right? The idea that Supreme Court says, you know what? We can't hold today that strict scrutiny is afforded because that will make things messy. So let's do this incrementally, right? Let's focus on Romer today. Eventually we'll get to a sodomy case. Then we get to the Windsor case, right? And then by that point, things are gonna be awesome. We can just strike down marriage laws. The groups bringing these cases are very smart. Like the NAACP Legal Defense Fund from decades ago. They're very incremental. And I in no way fault the strategy of these groups. The fault, I think, lies with the court itself that has a sort of transparent approach to incrementalism. That's like, okay, we'll do this here, but say it doesn't affect marriage. And we'll do this here, say, oh, it doesn't affect marriage. But anyone with the 2 brain cells, as Scalia's points out, can say this is leading towards gay marriage. Like that was the inescapable fact. I call this a slow motion train, right? It was moving. Everyone saw where it was moving. Everyone knew where the destination was. There's only one track, and it just took 20 years to get there. But that is how these cases began. Okay. So everyone get the context, right? 1996, the idea of gay marriage was still a figment of imagination, right? It was not even fathomable that this could ever happen in the present day society. By the time Lawrence happened in 2003, a number of states have started to provide various civil domestic partnership benefits, right? Fast forward to 2012 or 13 with Windsor, and a number of states have actually legalized gay marriage by the ballot or otherwise. And then we get to a Obergefell, which was decided not even just about a year ago, actually, which was a different beast altogether. So everyone get the sort of sociological chronology behind these cases, that the court could not rule in the manner they did in 1996 had it involved actually giving strict scrutiny. This may be in part why Justice Kennedy is so averse to tiers of scrutiny, but I don't think it is. Because even now in Obergefell, as you'll read tomorrow, he still doesn't give a tier of scrutiny. Even after the end goal, right? The train's at the station. Gay marriage is a constitutional right. He doesn't use the word strict scrutiny. He doesn't call it fundamental. He just talks about dignity. Everyone okay with this? Everyone get this? Okay, very good. All right, so let's walk through how Kennedy resolves Windsor. Again, he's not using any sort of scrutiny approach. He has this very different style of doing constitutional law. So, Rebecca, walk me through why does Justice Kennedy think that the Amendment 2 violates the Equal Protection Clause? Without talking about scrutiny, without talking about strict scrutiny or anything like that, how does he get this law to fail? What's his reasoning here? Okay, what's that word or concept? Dignity. Oh, what does dignity mean, Rebecca?
I guess something like human dignity, I guess I would describe it maybe first at a certain level that everyone deserves to be treated as such. I guess it's like a threshold that every person deserves.
Where do you get that definition from? I mean, it's a good definition. I think it's actually pretty solid. But where do you get that from? All you, right? Let's go back over Jacob. What's dignity? What is this?
He refers to it would have an adverse effect on homosexuals because it would like impose a special disability on them.
Oh, okay. So now we're getting more specific. Okay, Rebecca was being very good philosophical, but now Jacob's saying it imposes a specific disability. What is that disability, Jacob?
It would, it talks about it would forbid them from safeguards that others would enjoy without restraint.
Okay.
Or they can seek without restraint.
Okay. Very good. The language that Justice Kennedy uses again is very idiosyncratic. It's very not what you're used to, and the three opinions today should, in spades, give you an idea of what Kennedy thinks about at night. But Jacob's right. To Justice Kennedy, equal protection is not just about being treated equally. It's about giving people this equal dignity, this sense that they feel like they're treated the same in society, that people are not treated, or that it, I'm trying not to rephrase it because I rephrase it, I destroy its meaning. So I'm trying very carefully to say this, that by imposing these disabilities on people, you are demeaning them, that you're taking away their dignity. It's not just about inequality, right? It's about demeaning who they are as a person. I think I did that right. It's funny, one of you last night sent me an email saying that when they downloaded the PDF, it was all gibberish. And I said that was probably a correct reading of the opinion. I do my best to charitably characterize the opinion. So this disability, right? This disability, okay? Catherine, why does Justice Kennedy think that this disability was imposed? Like, why did the voters of Colorado choose this law to impose this disability? What was animating or motivating their intent?
I think he said it was a bare animus of
Perfect, exactly what I was looking for. This was the hippie case I mentioned last class, USDA versus Moreno. To remind you, in the 70s, you had all these hippie communes where all these basically young poor people would live together and collect food stamps. So the government said, okay, we're not going to give food stamps to the hippies. And the Supreme Court invalidated it, whatever, right? Was that a suspect class? Of course not, but who cares? But Justice Brennan, as his time bombs are wont to do, put this language in, where he basically said, government can't enact a law based on, quote, bare desire to harm a group. A bare desire to harm a group. Now, that didn't really impact that case, but Brennan would put this language in. And Justice Kennedy has cited this bare desire to harm provision in every single case he's written. You'll see it in Romer and Lawrence and Windsor, Berger. He keeps citing this language that if people act with a desire to harm a certain group, they're acting unlawfully. Doesn't matter if it's a suspect class, doesn't matter if it's a fundamental right, it's irrelevant. If there's a desire to harm, it's unlawful. Okay? So the basis reason why he thinks that Amendment 2 is bad was because it singles out a specific group for disability, and that's premised on desire to harm them. And that demeans their dignity. Okay? That's the equal protection component of the opinion. There's also a federalism component of the opinion. And this one's actually somewhat interesting. So, Catherine E., if a gay resident in Boulder, Colorado, seeks to change the law such that gays now get certain protections, what would his path have to be? What would he have to do? What's the only way that he could achieve that sort of a change in Colorado law, even at his local city level? And well, could the legislature even change this? Would voting be enough? What would have to be done, Catherine? Exactly, amendment. That the only way for this specific group to change the law, provide certain protections for them, would be to amend the Constitution. So what Kennedy says is that this law This amendment took out of their hands the normal lawmaking process and put it at a much higher level. That now you actually need to amend the Constitution to provide these sorts of protections. This should ring a bell of the Schuette case. This was a Michigan case where the people of Michigan tried to ban the use of affirmative action. Remember this case? And by constitutional amendment, they banned the use of affirmative action. You may ask yourself, wouldn't Schuette have been decided by Romer? Schuette didn't even cite Romer, which is why this case is so weird. Schuette was almost the exact same case, right? It's the exact same case. That the people tried to eliminate a certain benefit for certain groups by constitutional amendment. Hello. I was clerking when that case came up, so I know it very well, but it's the same case. Kennedy doesn't even bother citing it because precedent doesn't matter. It's whatever. Okay? So the two components here are this equal protection component, which is this animosity and hatred for gays and lesbians. And then we have this sort of federalism component. Mix it all together in the bowl, slice and dice, it's unconstitutional. Exactly why? Unclear. Does it affect any of their case? Wasn't even cited in Schuette, the Michigan case. So again, this case is somewhat of an outlier. I call it, again, a transitional case. It couldn't quite come out and say that strict scrutiny applies, because that would have really upended the apple cart. But it invalidated this ordinance and supposedly stopped other states from doing the same. So questions in the majority opinion in Romer? Any questions in the majority in Romer if we go into the dissents? No? All right. Oh, yes, Marissa.
Why are we talking about the full faith and credit clause?
Why are we not?
Why are we not?
Because it's a very lengthy discussion and it's beyond the scope of this class.
Even just as it's on the tail end of it, just like
What would you like me to tell you about it?
State accountability for SCOTUS decisions, doesn't that come out of the full faith and credit clause?
What?
Like, aren't the states held accountable to SCOTUS holdings under the full faith and credit clause? Like, if like a case arises out of another state, like Colorado, and the holding is affirmed, or the statute or whatever it is affirmed, and this becomes the federal standard. No other states honor that holding to the full faith and credit clause.
No. No. So the short answer is, why are states bound by Supreme Court ruling? It's actually, I'm asking, why are states bound by the Supreme Court's rulings? So the answer everyone wants to give is the supremacy clause. But we discussed in class that that's not the right answer, because the supremacy clause doesn't apply to judicial decisions. The reasons why states are bound by the Supreme Court is because of Cooper v. Aaron and President Eisenhower sending federal troops. It's not Marbury either. Marbury never said anything about state courts being bound. Might be a case called Martin versus Hunter's lessee, but not exactly. The reason why courts are bound by the Supreme Court is because otherwise they'll send in federal troops. The full faith and credit clause is not that reason. Mirza, if you want to learn more about the full faith and credit clause, take Conflicts of Law. It's offered once a year. Maybe 20 people actually take it. There's a very good class on how state laws are transferred, but it's a very good class which very few people ever take. But I really enjoyed that class. Let's move to the Scalia dissent. Scalia writes in his dissent, the court has mistaken a culture kampf for a fit of spite. I actually had a German student. She was from Germany. She sat right there last year, and I was so excited. I was like, finally, I have a native German speaker. I was like, what does a culture kampf mean? She's like, I don't know. But I was like, well, the book Mein Kampf means my struggle. She's like, I wouldn't know, because the book's actually banned in Germany. She didn't even know. I mean, which was shocking. But culture kampf literally means a cultural struggle. So the court has mistaken a cultural struggle for a fit of spite. Okay, what's Scalia getting at here? And again, this is a lesson which law students find difficult to accept. But one of the purposes of law is to maintain traditions. And if the law had been in a certain effect for several thousand years, Scalia says, they can use the law to maintain that until they're ready to change it. Right? That's his basically dissent in one sentence. If the law has been in a certain effect for years, millennia, and people morally disapproved of gays and lesbians, they can use the law to maintain the law in that respect. So to Scalia, This Amendment 2 wasn't about singling out gays and lesbians for any disabilities. Again, this is a dispute. Scalia says this is not about singling them for disabilities. Instead, what this law amounts to is trying to maintain the status quo and saying we will not give additional protections to these people. Okay, now, this is a debate, right? The cities of Denver and Boulder have already upset the apple cart, right? They already upset the status quo by providing these protections. So the effect of Amendment 2 was to withdraw protections that these cities already afforded. But Scalia said the state has sovereignty over all the little local municipalities, and they can say, you know what, these states were out of line. They shouldn't have done, these cities were out of line. They shouldn't have done this. So for Scalia, this wasn't a bare desire to harm gays, but a, quote, modest attempt to preserve traditional social mores against the efforts of a politically powerful minority to revise those mores through the law. Now, this isn't a language that gets people very up, the political powerful minority. So we discussed in class about a week ago footnote 4 of Caroline Products, right? This is this footnote in this case that spells out an entire constitutional theory. And one of the arguments advanced in footnote 4 is that the court should provide heightened scrutiny when a law affects discrete and insular minorities. Discrete and insular minorities. And what Scalia is alluding to here, that he made clearer in his dissent in Schuette, or his opinion in Schuette some years later, is that discrete and insular minorities aren't so powerless. What do I mean by this? Though small in number, Scalia suggests, these groups have been effective at changing the laws. They've been effective at persuading others to agree with them, right? A majority of people voting for these laws in Denver and Boulder probably weren't gay, but they accepted the fact that gays perhaps should have these rights. So what Scalia is saying here is this is in fact perhaps a small minority, but a powerful one. And if they want to change the laws, they can change the laws. But this is not a place for the courts to intervene. Dan?
But doesn't Scalia only address half the issue? He says that, okay, it doesn't give additional rights. But the flip side of that is it doesn't allow for remedies.
Right, that's the point I made before. And in fact, it's actually a stronger point is it doesn't just, it actually, in fact, withdraws rights. Right, because cities of Denver and Boulder had enacted this. So it's not just maintaining the status quo, it's about withdrawing rights altogether. Right, this is the dispute. Kennedy says you're withdrawing rights, and Scalia says you're maintaining the status quo. Both positions have strengths and weaknesses, but at a minimum, Scalia says the state has the power to control their subdivisions. Right, you may not even appreciate this, but the fact that we have a Houston council is only because of the grace of the people in Austin. If the people in Austin decide otherwise, the city of Houston would cease to exist. They'd merge us with, like, San Antonio. They could do that tomorrow, right? The state has no responsibility to even maintain cities or their laws. This is the point which you cannot get, but it feels like that Aspen and Denver did this as irrespective. What matters is what the state constitution says, which trumps any of these local laws. John?
So why do you think that Scalia starts bringing up this theory of democracy? Is also not in the Constitution, right? Democracy is not in the Constitution.
It is not. I'm so glad you said that. It's not.
Yeah, so like, and also, I guess the second point would be, isn't that actually democracy when there's a minority group that can actually sort of,
Well, but they lost though, right? So they passed the local laws, but they were beat on the state level.
I know, but so there's a difference between the first question is why is Scalia even talking about democracy if he's such an originalist? The second is it seems like this is democracy when there is minority groups changing what other people are thinking and trying to, if the slow train is going, and it's being guided by a minority, then that seems to be democracy in action.
He's fine with that. In fact, through his Lawrence said, he says, I have no problem with states changing their laws. His objection is only when the courts step in and alter them. Right?
Okay.
And in fact, the reason why I think he's articulating this theory, as we'll see, is he sees it writing on the wall. He knows where this is going. Right? He knows that at some point, before the states legalize gay marriage, the court will do it for them. He knows where this is.
He just wants the states to do it, not the court.
He's fine with democracy, right? I mean, we don't have a democracy in the federal sense, but at the state level, we sure as heck do, right? States can have whatever system of government they want. And if the states want to vote to repeal marriage laws, repeal sodomy laws, let them do it. Scalia's made this, and again, I don't really talk about Scalia too much, but I find it, I compelled to in light of his passing. But Scalia said, you know, as a matter of personal preference, what I think doesn't matter, right? He said, I would execute, if I were king, I would execute every flag burner. He said that. But I'm not king. I'm here as a judge interpreting the Constitution. And he invalidated the flag burning law in Texas versus Johnson. He makes a point very clearly many times that even though perhaps I may not agree with these laws giving gay rights, that's irrelevant. And he says, democratic process is fine. I think this is the number one reason why people misconceive Scalia, and I think it's unfortunate. They think the mere fact that he finds that there's no constitutional right to X means that he hated those who do X. It's not the case. It's not, and I think it's actually, as a graduate of the Antonin Scalia Law School, perhaps I feel compelled. But he makes very clear that these are not his personal views, although people read it in that fashion. To answer your question, John?
The latter, not really the former. This is why
What did I miss?
Where this theory of Marxism sort of originates in his own.
There's nothing unoriginalist about saying people can vote to change the laws. There's nothing unoriginalist about this.
Well, I guess it doesn't. But usually, I would think that he would say, "Look, well, we should look at the Constitution, and well, why should I rely on something like a theory of democracy when?"
But people can vote. But people can vote to give additional rights beyond what the Constitution provides, right?
Well, I guess I was assuming that he would give like a rational basis argument, or something, another kind of scrutiny argument, or non-fundamental.
All Scalia will say is the Constitution's silent on this issue. Let the people vote. The Constitution's silent on gay rights. Let the people vote. And that's the position. The Constitution's silent on abortion. Let the people vote. Okay. So we're gonna get the first. Yeah, Samuel.
I think so. Kind of get a level of letting people vote. People should rule. That's great. But then you have different levels because I think currently it's a very popular thing. More local government, more local is better. Because then it can be most. But then you have kind of a mid-level stopping down. Saying, each current example for me is the city of Denton passed a fracking ban in the city limits, and then the state of Texas said, no. We like to say that we like local, more local, more local, more local, and then wait, your local disagrees with what we want. So and that's where I see like,
well, that's why I said
saying democracy, we want to protect these protections, and then you have a different group saying, yeah, no.
So I said this before, but as a matter of local government, the city of Denton, the city of Houston don't have to exist. Tomorrow, Austin could decide, you know what, Houston and San Antonio, you're not one city. San Antonio, whatever, right? Mm-hmm. Whatever. You're one city. Local governments exist at the pleasure of the state. That's the point. I mean, they do. They exist at the pleasure. The state can abolish them tomorrow. So you know what? City charter, we're going to avoid it. Go make a new government. So, in terms of local government, I think we're talking about the states, not the municipalities.
So that's and I realize there are a bunch of different.
I mean, people in the city council love talking about local government, but they exist to create the state. The state could abolish them tomorrow. Okay. The next part of Scalia's dissent focuses on precedent. And he says, look, we have this precedent in the books, right? Bowers. It's not even 10 years old. Bowers said, we don't apply heightened scrutiny for gay rights. There's no fundamental right. How can the court reconcile this decision with Bowers, right? Why don't they just go ahead and overturn Bowers? And I think Ashley said it right a few minutes ago, because of Casey. They just had this beautiful, majestic statue of how precedent was important. So, they're going about talking about precedent, but then they're not even following it. So what gives? Okay. And towards the end, Scalia talks about, polygamy, right? The admission of the states of Utah to the Union was contingent upon abolishing polygamy. Polygamy is with multiple wives. I don't think it's multiple husbands, multiple spouses, right? Does that not impose a disability on those who are polygamous? Does that not demean their existence? Of course it does. But Scalia wasn't just talking about polygamy. He was talking about marriage, and he's saying, look, if you want to lift that barrier, and you say that we can't demean gays and lesbians by treating them differently, the marriage laws are they can't stand. So he's hinting at it here. Indeed, does anyone know that show, The Sister Wives? Never seen that? Want to tell us about it?
Well, I actually lived across the street from them.
Where was this, in Utah?
No, it's in Las Vegas.
Las Vegas, okay.
My grandfather was actually friends with Cody, and when they were building their house, my grandfather talked to Cody and living across the street from us.
Oh.
So my truck's actually on the TV show sometimes.
Ah, okay, well.
But they're a family of one husband and 4 wives, and countless kids. I think there's like 17 or 18 kids. And they practice polygamy. They live in 4 houses. All
But be careful. They're not actually legally married.
They're not legally married. He married his first wife, divorced her. Married his second, divorced her. So I believe he's only currently married to the 4th wife legally, but they all claim to be married.
So Utah has a law that even prohibits that, holding yourself out as married, even if you're, I'm sorry, and Nevada as well, but the states have these laws saying even if you hold yourself out as married and you're not legally married, it's still illegal. So immediately after Bergefell, a constitutional challenge was filed against this law with the sister wives, cast members as a plaintiff. The district court actually ruled, following a Bergefell, polygamy laws cannot stand. Court of Appeals, 2 days ago, perfect timing, 2 days ago said, we're not going to rule the constitutional case. Because Utah wasn't actually going to enforce this law, the case is moot. They dismissed it. They dodged the issue. It'll come back up eventually. Incest laws as well. We'll get to that later. All right, so any questions on the Romer case? Did I see a hand? I think I missed it. Any questions on Romer? No? No? Okay, we'll on to Lawrence. So we have a case from our backyard, from Harris County, Texas. I'd like to give you a factual history of this case, because the facts as recited in Justice Kane's opinion are entirely, well, mostly wrong. So in the account that is in the book, 4 sheriff deputies from the Harris County Police Department were called in. And there was a report that someone had a gun in a house and there's some sort of threat. So as the standard thing goes, the cops knock in, they identify themselves, they walk in, and they see Mr. Lawrence, John Lawrence, and Tyrone Garner engage in an act of sodomy. The police report says that Lawrence was aggressive, and they arrested them, and they sent him to jail. Okay? The cop could have just done nothing, right? There was no actual gun. But the story is they went to jail, they pleaded no contest, which basically like a not guilty, and then this case went appealed all the way. Okay. Let me tell you what really happened. So Mr. Lawrence tells a very different story. He said, I'm going to quote him, he said, "My God, we didn't have sex." Okay? So there were 4 police officers. Okay? 2 of them did not note any sexual activity. Okay? 1 of them recalled seeing oral sex. The 4th recalled seeing anal sex. How do I put this? There's a difference between oral and anal sex. If you were to see the 2, it should be painfully obvious which is which. That wasn't deliberate. So the police here screwed up, right? The police here made a mistake, right? 1 of them was flatly wrong. As the best I can gather, and this is, I mean, I've read a lot on this, Garner and Lawrence were probably not fully clothed, and let's say they were cuddling, but there was no actual, I can't quite, they didn't actually know what they were doing, but they definitely were not fully clothed, and they were on a couch or something, whatever. But there was no sexual activity going on. And again, the oral and the anal, you don't confuse the 2, right? So I guess these 4 police officers were so stunned by what they saw. It's like, oh my God, they must be having sex. They're 2 men. I'd be remiss if I didn't know 1 was black, 1 was white. I'm almost positive that went to the decision to charge the 2. This is still Texas, right? So in any event, the actual facts of the case, they may not have even been violating the law, the letter of the law, when the police found them. I mean, I'll take John Lawrence at his word and say they were not engaging in sex and that they weren't, but by all accounts, they weren't actually breaking the law. Okay? What happened next? Okay? So since Windsor, not Windsor, Bowers in 1986, various gay rights groups have been looking for a case to challenge a sodomy law. The reason why they didn't challenge it because there were no cases. In fact, Texas had said that before Mr. Lawrence was charged under the provision, they had never prosecuted anyone under this. Again, the obvious reason why. Generally speaking, cops don't sue people in the act of having sex. It's very rare. I suppose it happens, but it's going to be a very rare case. So various gay rights groups actually got a hold of Lawrence and Garner and said, listen, we need you guys to not, they could have just pled guilty and they paid a fine or something stupid, right? They said, we need you to plead not guilty because we want to appeal this case to the Supreme Court, okay? This is where politics come into play. The Harris County DA at the time was a guy named Chuck Rosenthal. I'm not being very nice about him. He was an idiot, right? You can Google this. I'm not making it up. He was not very smart. He should have dropped this case immediately. Just drop the charges. He should have dropped it. There's no reason to prosecute this case because they wanted a Supreme Court decision out of this, right? That's what they wanted, right? They wanted this case to go all the way. He should have dropped it. The second mistake he made was that he decided to argue the case himself. At the time, Texas had a Solicitor General, was it Cruz? It might have been Cruz's predecessor. They had an SG who could have argued it much better. He was awful, okay? If you ever want to listen to really bad SCOTUS arguments, go look at Chuck Rosenthal and Lawrence. It's terrible. It's a matter of even got 4 votes, right? Really bad. So this is how stupid local Harris County politics changes constitutional law. This case should have been brought. They should have dismissed the charges, and he should have someone smarter argue it. But this is the world that we live in. So by the way, why? This is also, there was a book written about Lawrence and Garner called Flagrant Conduct, which I encourage you to read, by Dale Carpenter. Why was the cop called to Lawrence's apartment? So again, I've pieced this together by rumors, but apparently Garner was helping Lawrence move some furniture or something. Okay, Garner's boyfriend was really jealous, and Garner's boyfriend suspected that he and Lawrence were doing stuff. So Garner's boyfriend, who was also gay, called the cops and told them, go to their apartment, there's a gun, because he knew they were having relations. This case is like an awful soap opera, right? I mean, but this is what gave rise to this case. That those facts were not in the book. Anyway, any questions on the outset of the case? Yeah, so it's called Flagrant Conduct by Dale Carpenter. It's a very good book. He actually interviewed Lawrence. I mean, Garner died some years earlier, but he interviewed Lawrence. Lawrence actually died about 2 or 3 years ago as well. But I encourage you to read that book if you have a moment. Okay, so we're in 2003. I was at 17 years after Bowers, roughly the same period between Roe and Casey. We now have 17 years from Bowers to Lawrence. Okay, so the 2 major themes of this case, right, as always, are whether, in fact, there is a substantive due process right to sodomy, and if so, how do we deal with precedent? How do we deal with stare decisis? Okay. So I want you just to contrast the opening sentences. I don't love. Justice Kennedy's opinions are fascinating to read, not for their substance, but for their style. I often think if Justice Kennedy had a different life, he'd be writing greeting cards for Hallmark because his soporific language, sappy language. So how did he begin Casey? Well, both at the same time. That's pretty cool. How did he begin Casey, right? See, but one of them closed the door quietly. How did he begin Casey? Casey began, well, liberty finds no refuge in jurisprudence of doubt, right? We can't have liberty if the law is uncertain. Yeah, we did this last class. How does he begin this opinion? I'm going to read it because I can't improvise this. Liberty, again, liberty starting. Liberty protects the person from unwarranted government intrusions into a dwelling or other private places. I'll skip a few lines. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. The instant case involves liberty of the person, both in its spatial and in its more transcendent dimensions. Austin, in your own words, please, what does that opening paragraph mean to you? In your own words.
Basically, I'm right.
What do you, oh, who's right? What do you mean I'm right? Elaborate, please.
Whatever he believes liberty is what liberty is.
All right, so let's be more charitable, right? It's really easy to jump on Kenny. Let's try and actually figure out what is he getting at, right? It's really easy. This is just gibberish. It's a symbol of letters, whatever. Let's actually try to. There's something there. What do you think he's getting at? I want you to actually try and read him and take it as word. What's he getting at here?
I mean, I guess that you have a right to do whatever you want to do in your own privacy, I guess.
Okay. You want to take a stab, Tech?
You allow people to make the choice.
What kind of choices can people make?
Protected by choices protected by the Constitution.
But in what realm can they make these decisions? What areas of life can they make these decisions?
Personal liberty, which the government may on.
Okay. All right. Close enough. Okay. Again, it's really easy to just make fun of the language, but I want you to try to actually figure out, because he's getting at something, right? There's a theme what he's getting at here. This opinion does not begin by saying sodomy is a fundamental right, therefore strict scrutiny applies, therefore we overturn Bowers, right? He doesn't get that. He actually seeks to redefine what liberty is, totally separate and apart from the court's 40 years of case law. What he says at the start point is, right, liberty protects government intrusions into private places. Okay, Fourth Amendment, right? There is a Fourth Amendment. The government can't make unreasonable searches into your home. Cool, we're with that, right? The state is not omnipresent in our home. But there are other spheres of our lives outside the home where the state might be a dominant presence. Again, this is weird because Lawrence was arrested in his house, but whatever. Then comes the key. Freedom extends beyond spatial bounds. What he's trying to say is, we shouldn't think of freedom in terms of where are you physically located. Do you have a right to be there? Is this your house? Are you on the park? Whatever. Freedom transcends, right? Freedom goes beyond our narrow sense of places. Freedom, liberty, he writes, presumes an autonomy of self. That means you can decide and determine who you want to be as a person. That includes freedom of thought, belief, expression, and conduct. So here's the key move, the last one, right? No one disputes that you can decide who you want to be, what you want to think, how you want to express yourself, what religion you want to be. But he adds another one at the end of the list, right? Intimate conduct. That the state can't control your mind, nor can they control certain conduct that's of a pure intimate nature. So this case for Kennedy is troubling because it's both of the liberty of the spatial, that is, the guy was in his house, and this transcendent dimension that they were trying to control who he is as a person. Okay? So it's not equal protection, right? It's not really due process of law. It's actually defining a person's essence, and the state's trying to infringe upon that liberty of the person. I think I did that right. Does everyone get what I'm saying? I mean, it's not easy. You really have to claw through his language, which is dreadful. But he's getting at something here. Everyone get what I'm saying? Yeah, I see bewildered looks. It's okay. So from this frame, he goes on to discuss the facts of the case, blah, 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 blah. And he goes through all these various precedents, right? He goes from Griswold to Eisenstadt to Roe, and he talks about Casey, he talks about Bowers. Now, he tries, on the one hand, to explain the Bowers Court was wrong. He says the Bowers Court said that there's a long-standing tradition and history of laws that criminalize sodomy. But this is different, right? Shelby, why is Texas's sodomy law different than the sodomy laws of all these other states going back thousands of years? What about Texas's law is different? Why is Texas's sodomy law different than Georgia's sodomy law? This is the key point of the O'Connor dissent or O'Connor opinion. Michelle? I'm sorry, louder, please. Yes, exactly. The law in Georgia and elsewhere made sodomy a crime, period. That is, if a man and woman engage in anal sex, a man and woman engage in oral sex, didn't matter. Sodomy was a crime. The Texas law said specifically it's only a crime to have sodomy between people of the same sex. So all of you Texans who are of the age of consent for 2003, you are welcome to engage in heterosexual sodomy, but you cannot engage in homosexual sodomy. Congratulations, right? Justice O'Connor has a snipe about this in dissent. She said, if the state actually criminalized sodomy between heterosexual couples, the law wouldn't last very long. And I'll leave that to your own devices. Okay? So Kennedy sees this as being singling out to target gays and lesbians and demean their dignity. You see the Romer head thing, right? That they're singling these people out for disability. So if you're a heterosexual, you know, have at it, right? Do whatever you guys want. But if you're homosexual, you cannot engage in these sorts of acts. Okay? But wait a minute, but there's a history, right? Going back to Leviticus, right? Of saying that homosexuality is an abomination before the Lord. You guys can quote your scripture better than I can, right? How is it then that these laws which have been in existence since like the time of like, you know, Jesus, right? You know, long time, suddenly become unconstitutional? Kennedy says, our obligation is to define the liberty of all, not to mandate our own moral code. In other words, even if this morality issue has been around forever, we don't have to follow it. We have to define the liberty of the Constitution, whatever that happens to be. So how do we treat this 2,000-year unbroken chain of condemnation of homosexuality? Well, look at the last 50 years. In the last 50 years, there's been an emerging awareness, a trend, if you will, that liberty gives protection to adult persons in how they engage their private lives. Right? Only a handful of states still have these sodomy laws. And the fact that these states are starting to repeal these laws is a reflection of how our Constitution views gays. Now, you may think, wait a minute. How can the Constitution, which was written 200 years ago, and the 14th Amendment written 130 years ago, be affected by the way states define rights? Cindy, how can this be? How can we look to what states are doing to inform what the Constitution means? Like, how does this work? Justice Kennedy. You ever thought? Natalie? In what respect do states changing laws and repealing sodomy laws, how does that inform the federal constitutional inquiry? To Justice Kennedy. So does the Constitution change based on what the people are doing and what kind of laws they're making and enacting for Kennedy? Okay, so this is actually an interesting aspect of Kennedy's jurisprudence. If Scalia is an originalist, Kennedy is an anti-originalist, right? History doesn't matter much for him. He says it's a starting point, but that's about it. For Kennedy, what matters is a growing awareness of expansion of rights, that states are repealing sodomy laws, and later that states are granting gay marriage rights. This informs his federal constitutional inquiry, right? What's tricky about this question, though, is if the democratic process is moving this way, why don't you let the democratic process continue moving, right? That is, if states are repealing their sodomy laws, why don't you just wait for Texas to repeal its sodomy law? But that poses no meaningful limitation. One of the more controversial aspects of Lawrence at the time was the citation of international law. He cites all these foreign court decisions, right? Now, he doesn't say that these foreign court decisions define American constitutional law, but they reflect a growing awareness of how Western civilization views this issue. And to the extent we have these shared traditions and values, it should inform the inquiry. This is a very, I can't even explain, the senators flipped out, and virtually almost all of the confirmation hearings, not all, but a significant number of confirmation hearings after that point involved citation of international law. This became a huge deal. Okay. Yeah, Scotty, you your hand up?
Yeah, I was gonna say Kennedy's quote, "Evolving standard and the meaning of equality." To me, doesn't that sound like he's going for a living constitution model? Like it
Oh, absolutely.
Means just what this generation wants it to mean, and I feel like evolving standard just opens the door to whatever he wants it to mean next time this issue arises. Like that's not a very, that's not a very rigid or strict construction. It's whatever we need it to be.
Do you want to disagree with that?
Oh, no. No judgment, no judgment.
I mean, I understand some of the issue. What there's a connotation there or not.
No, I mean, the opinion by Justice Kennedy is emphatically a living constitution. I mean, he makes no. Perhaps my sarcasm was like, duh, yes, right? He emphatically defends the idea that the Constitution means whatever society wants it to mean. And perhaps one of the themes which we can address going to Obergefell, Justice Ginsburg made this point a number of times. She said that the Supreme Court could have struck on California's Prop 8 in 2000, was it 12 or 13? They didn't. And Ginsburg said, I don't think society is ready for it yet. 2 years later, she said, I think we're ready for it now. Right? The idea that constitutional law moves when people are ready for it. It's a striking idea that 9 judges can decide when society is ready for something, whether right or wrong, with Roe or Obergefell is another story. John, then Natalie?
Do you think that Kennedy's reasoning in this quote, like freedom, extended conservation bounds, remind me of the Wickard v. Filford case?
Oh, that's interesting.
The farmer, so like the argument would be like, look, regardless of what the government says, he's a farmer. Who he wants to be as a person is a farmer, right? And so like, it wouldn't just be on this like
it demeans him to restrict how much wheat he creates, right?
Yeah, like I think so. Like his value as a person is given by how much wheat he creates, and it's not restricted by what the government and how the cost of wheat is anyway.
If only the New Deal court had an idea of dignity, they could have struck on the New Deal that way, right?
Yeah. No, like I just feel like you can expand this, like certainly the comment to also like who you want to be as a person and identify that with occupation also. So it seems that
Natalie?
Well, I'm just going to comment and say that a few minutes ago you said that it's strange that Congress decide what society is going for. And I don't think they necessarily make a decision as much as like they've been servants of society. And also, I don't think it has to be one or the other in terms of like strict interpretation of the Constitution or the Constitution. I think there's some for both to coexist.
Okay, I'll answer your first one because the strict versus living, that debate goes on forever. But to the extent that the court is citing a general awareness, right? You'll read this in the Obergefell case next week. By the time Obergefell came to the court, 12 states had legalized gay marriage. 12. 38 had not. The court cited the fact that 12 states had legalized as a growing awareness that this is where we should go. So in terms of making an observation, they don't count very well. Right? And I don't say that lightly, but in another area of the law with Justice Kennedy with the death penalty, in order for him to decide if a thing violates the death penalty, he counts the number of states. So there was this one opinion where it was a case called Kennedy v. Louisiana, involving whether you can execute a child rapist, right? Generally, you can't execute a rapist. The case was here, could you execute a child molester, a child rapist? And Louisiana sought to execute this guy named Kennedy, totally by chance. And Justice Kennedy said, there's not a single jurisdiction in American law that permits the execution of a child rapist. And he wrote, and as a result, it's unconstitutional. He was wrong. In fact, under the UCMJ, the Uniform Code of Military Justice, the military law, you can execute a rapist. And the court, someone actually wrote about this, the court actually amended their opinion with a footnote saying, well, almost all jurisdictions. So even where it's really clear how to count, they didn't count right. So with respect, I don't trust judges to count these sorts of these sorts of things. But I think the second point is a very well made point. Okay. Everyone with me? Oh, yes, go ahead.
How does he distinguish this concept of dignity from being in itself kind of applying a moral code or standard upon society, particularly how that dignity is defined and whether a person should be defined as broadly as being attempts to it?
Well, you want to try to answer your own question?
Do you want?
We want to try to answer your own question?
Sure.
Go for it.
Oh, well, actually, no. I thought there was going to be a follow-up.
You want to answer his question? We'll give it a stab.
There you go.
His question was, you got to pay attention, Mirza, man. You got to.
That's too much. That was like 3 lines. That was too much.
All right, well, we all manage. So the question was this, right? The question was this. Kennedy says we should not be imposing a morality code, right? If I'm reframing your question correctly, but isn't Kennedy's conception of liberty its own morality code?
Shifting morality. It recognizes the shifting morality in the last 50 years, how we look at people with different orientations.
Who's we?
We the people.
Did we the people vote for this?
We the people ratified the Constitution.
Did we the people vote for this, Mirza?
I mean, if you're looking at this from some kind of departure from, I can't interpret the Constitution as a dead document because I'm looking at societal shift.
I. Okay, good. You should fix your pronoun. Now it's the I, not the we.
Yeah. If you're saying I can't do that and say that because I feel this way and that my sentiment cannot be supported by we the people. Like, I don't think the dead living distinction really is like, there's not a big enough definition for me in the way that I see it. But yeah, shifting morality. I mean, like you said, I mean, we admitted Utah, they're not polygamous anymore. How is that not a shifting morality?
Anyone else? John?
Maybe you would argue that, like, if you look at autonomy is independent of
John, this way. Thank
you.
Always, I think it's always, if you're in court, always speak to the judge, not to opposing counsel. So just practice. So this way, yes.
Well, autonomy is we would have to argue that autonomy is somehow not a moral, value. It's something that's within persons themselves that would, you would make that distinction between like autonomy as having value, it's sort of human value.
So that would then mean that if people can engage in intimate conduct, right?
Yeah, but not necessarily a moral value. So like, there's no moral code that says that you should have a certain job or anything like that. Separate.
Anyone else want to take a step? Yeah.
My guess is
this way, Sam.
Right.
Yeah.
My guess is that he.
It's the easiest way not to get confrontational because when you start talking to each other, it's just, if you're talking to me, I'm like, I'm cool. I don't.
My guess is that he would say that it's different when you're giving someone rights than when you're taking away, and that's how he would look at it.
So is this a case where people are giving rights or taking rights away?
He would look at it as giving rights. Like people should be able to have sex with people of the same gender if they want. Is how he would look at it. Whereas Scalia on his side would say, well, the general consensus over the course of our nation has been that we don't like homosexuality, so that's the other side of the same moral coin.
Well, I think Scalia would say if people want to repeal it, let them repeal it.
Exactly.
And then be done. Scotty?
I had a question on the Casey jurisprudence.
Well, I was going to get there next. Good. Okay. Perfect.
Okay.
Yeah. That was my next point. So perfect. So what's your question? Go ahead. Ask and I'll lead into it.
My question on the Casey jurisprudence is they don't want to overturn things that people have substantially relied on. That's the way I understood it.
That's exactly
And,
good.
Because they don't want to, in Casey, they didn't want to take away somebody's right to an abortion because that is a right that has now been relied on for quite some time. Conversely, how do you rely on a ban to sodomy?
Oh,
And
okay.
So my question was, this might be a bit of a departure.
No. Okay, so let me rephrase your question. I was gonna make that point about 2 minutes, but I'll do it now. Okay, so the Casey court said that in the 19 years since Roe, there's a reliance interest on this thing, that women have come to rely on this, they've come to expect that if something happens, they come to abortion, right? Reliance. The sodomy law had never been enforced, right? It had been in the books for a number of years, never enforced. What is the reliance interest here? And I'll give you a hint, it's not sodomy. What is reliance interest here? And I'll give you a hint, it's not sodomy. This is the point that's clear. It doesn't make it as clear as it ought to, but I try to answer this guy's question. What is the state's reliance interest here? No, be more precise. What is the state's reliance interest here that's uprooted by Lawrence? Beyond Bauer, because sodomy laws are never enforced. What's the broader principle that Lawrence repudiates?
Ability to pass other laws regarding homosexual.
No, not just homosexuality, regarding bigger than marriage. Morality, bingo. Okay. What Lawrence stands for, is a proposition that the state can't pass the law merely because they find something immoral. To criminalize sodomy because they think it's immoral, well, that demeans them. It takes away their dignity. The reliance interest here is not about sodomy. Don't kid yourselves, right? It's broader. Basically, the court's signaling laws based on morality cannot stand. And, oh, by the way, that means marriage laws too. But it is an umbrella of morality. Prostitution, polygamy, whatever you want to say, laws based purely on morality, those laws have to go. It demeans the person to tell someone that they can't marry 3 wives. Demeans them. Who are we to say that they can't have that many spouses? Or who do we think we are, right? As you'll read that quote in John Roberts' Dissent next class. John?
And that sort of goes back to Yale's point, which is demeaning someone seems to be a moral judgment. Whether or not you're making that decision, who's making that decision? Still
Yeah.
seems to be a moral judgment.
Okay. Okay. Yeah.
Yeah. I mean, the court, Kennedy kind of strays away from going into substantive due process and trying to define a liberty interest, basically stating that it's fundamental right, in essence, which would have cleared up a lot of the muddiness that this created. Almost, and Scalia kind of goes into it also and saying like, hey, if you want to do this, I mean, that's cool, call it a fundamental right, and run through strict scrutiny.
Right.
But instead they say, well, we'll go through rational basis, and well, they don't really have rational basis. Well, kind of do, but
yeah,
since that's such a loose standard.
Right. Okay. Good. Both good points. So, in the final paragraph, right? I'm sorry, maybe the second to last paragraph of the opinion, Kennedy writes, "Here's what this case is not about." Right? He says, "It does not involve whether the government must give formal recognition to any relationship that homosexual persons seek to enter." Okay, so I guess it doesn't involve gay marriage, does it? Well, again, if you have 2 brain cells, which everyone in this room thankfully does, you could put together 2 and 2, and you can see where this train's headed. It's a very slow train. I mean, I lived through this. I mean, maybe you didn't, but I went to law school starting in 2006. Like, everyone knew where this was headed. It was the most anticlimactic thing ever. It was, it was a very slow train. Okay. Any questions on the majority before we move on to the O'Connor and then the Scalia? Any questions on the majority? Oh, yes, go ahead.
Kennedy kind of generally, his proclivity to use dignity and that side of things instead of
Proclivity to use dignity. I like that. That's good.
instead of like Travis was saying, going towards just establishing, well, this is a fundamental liberty interest because X, Y, and Z from the Constitution and history, and so we're going to say it is. Instead of doing that, is that really just him being averse to substantive due process, accepting substantive due process?
So again, I gave 2 answers to this question before. I'll give the same answer now. Had the court went and actually held that strict scrutiny is appropriate, then immediately marriage laws would have fallen. And in one sense, the court wasn't ready for that. But in the second sense, Justice Kennedy just doesn't like scrutiny. He doesn't like labels like fundamental rights. He likes this broad philosophical language about dignity. Because even in a Burgerfolk, once the ball game was over, he still didn't talk about scrutiny. So he doesn't like tiers of scrutiny. Doesn't matter to him.
My question though is that second part. What is that? Why is it that he doesn't like it? And
I don't know. I mean, how do we get in Anthony Kennedy's head? I have no idea. He's a very unique thinker. And if you read his speeches, I mean, I read through his confirmation hearings. In 1987, during his confirmation, he was talking about dignity of the person. He was talking about all this stuff back then. He has this stuff in his head. He goes every year to Strasbourg in Austria to study with European judges. Doesn't influence him. I don't know where he gets this from. I wish I knew. I don't. It's whatever. Right? It's whatever. I realize that's not a very good answer, but that's the best I can do after studying this stuff for many years of my life, and that's whatever. Atlas shrug. I don't know. I don't know. It's whatever Kennedy wants. Yeah. Let's talk about O'Connor. O'Connor, who actually was in the Bowers majority, doesn't overrule it, but she says it violates equal protection, right? Because it treats same-sex couples differently than opposite-sex couples. Well, the court said that sexual orientation is not a heightened scrutiny, so is this some sort of rational basis? Well, she said even under rational basis, this fails. How? Well, she cites the Moreno language. She says, well, a bare desire to harm is not a legitimate basis. This is just merely a desire to harm gays and lesbians. Okay? At the very end of her opinion, she says, but don't worry about marriage, right? The state still has a strong institution to preserve the tradition of marriage. Again, don't believe it. In fact, O'Connor, in her personal capacity, has supported the Bergefell decision. She thought it was right. So even when judges say it doesn't support gay marriage and they're off the court, they still change their minds. I don't have much to say about that. Anyone have questions on O'Connor? She's like, well, I join the opinion. I can't overrule it, but I'll overrule it anyway. Whatever. Okay. Move on to the dissent. In my notes are Scalia, J, dissenting, and pissed off. There's actually an expletive before pissed off, but I won't read that one out loud. If you ever see my notes, there are lots of curses usually. I have very good, very detailed notes. So Scalia leads off. He was livid with this one. He was livid. He leads up and says, liberty finds no refuge in the jurisprudence of doubt. That was the court's sententious response barely more than a decade ago to those seeking to overturn Roe. Sententious means like disingenuous. The court's response today to those who have engaged in a 17-year crusade to overrule Bowers is very different. The need for stability and certainty presents no barrier here. Okay. So, the first part of Scalia's dissent takes issue, and I'm going to lecture because we're running low on time. This class is way too much to fit today. I want to make sure I get to Windsor. The first part of Scalia's opinion talks about precedent. He said, listen, we were just given this entire lecture and case about how precedent was so important. And here we just overruled Bowers, a 17-year-old precedent. What's at stake here, right, in terms of reliance interests, is not just sodomy laws, but the power of the state to enact morality laws. All those laws go away. The next part of Scalia's opinion, it talks about doctrine. He says the majority makes no effort whatsoever to say, is this an equal protection strict scrutiny case? Is this a substantive due process fundamental rights case? We don't know. Basically, like, whatever. I'm only slightly exaggerating. We don't know what this case is. We have no idea. Okay? He has no idea. And the failure to make any sort of doctrinal fit, to make this fit into doctrine, will lead to uncertainty. Scalia says, quote, state laws against bigamy, same-sex marriage, adult incest, prostitution, masturbation, adultery, fornication, bestiality, and obscenity, sounds like a title of a really bad porno, right, are likewise sustainable only in light of Bowers' validation of laws based on moral choices, right? Every single one of these laws is called into question by today's decision. The court makes no decision to cabin the scope of the decision to exclude them. The impossibility of distinguishing homosexuality from other traditional mores is precisely why Bowers rejected the rational basis challenge. Okay? What do we have here? Scalia is saying all these laws, I mean, you may not have known there are laws on masturbation, but you are probably aware there are laws on prostitution. There are laws on obscenity, that you can't engage in certain speech acts that defy community decency. How can any of these laws remain on the books? This goes far beyond sodomy. Indeed, in many European nations, prostitution law has been repealed. Indeed, even some adult incest laws. So one of the most unintentionally popular blog posts I ever wrote, which will become obvious for reasons I'm saying in a minute, is what is a state's interest in criminalizing adult male incest? Okay, one of the purported reasons why you ban incest is because you have a fear of certain recessive genes that we passed on. I'll get to that in a second. Adult males who are related cannot do that. They can't reproduce. Okay, what's the state's interest? So I had a provocatively titled blog post, why can't two brothers have sex? Which, anyway. The second issue is we allow people who are both carriers of recessive genes to get married. For example, Jewish people have a common ailment called Tay-Sachs. It's this debilitating disease. Two people who are carriers who will guarantee give their kid this disease can get married. So the entire male-female incest thing doesn't really make sense either, which is why the sister wives case was a curious one to follow. What is the state's interest in proving these? And the answer is, after Lawrence, none. Okay. Scalia moves on and he says, the opinion talks about liberty and dignity, which is fine, but those are not phrases that the Constitution, liberty is, but dignity is not. It's not something the Constitution protects. Laws prohibiting prosecution, recreation of marijuana, or Lochner, working more than 60 hours a week in a bakery, are all liberty. And so there's this shade of Lochner. Okay. Okay. At the end, he basically says, there is no reason why this will stop and be limited without going to gay marriage. He acknowledges this train. Okay. And he says at some point, this opinion will be cited for that proposition. Okay. Finally, he says, and this is actually John's question before, I have nothing against homosexuals promoting their agenda through democratic means, right? If perceptions change over time, let them vote on it, and there's no problem there. But what cannot be done is for the court to step in and intervene in the manner they did. Yes, Samuel.
Why did not address it? And I'm not saying this. He obviously cites a long list of things that are morals that are regulated by law. But there's some things like, for example, bestiality. Well, it's still animal cruelty.
Mm-hmm. What if a person owns their own livestock? They can slaughter them.
Right. I mean, so there are.
I mean, you can kill your animal.
You have the right. You have the right to do certain things to your animals. You don't have the right to do other things to your animals.
But could a state regulate based purely things immoral? I'm not joking. There actually are groups that actually profess bestiality should be legalized. I'm not.
And I don't doubt that.
No. There are groups who say that they actually have relationships with horses, and that's actually a matter of love. I'm not. You can Google this. It's, you know.
I don't doubt you at all.
So again, you're demeaning their existence by saying that they can't have love with Mr. Ed.
Right, I'm just saying. and I get that.
Mr. Ed and Lover. No.
And that is a strong point, but it pretends like if you strike away this law, all of a sudden there would be no laws whatsoever.
Well, laws based on morality, based solely because you think it's immoral to do something.
Right, but that's ignoring laws that are not based on morality.
So what if it's a mixed motive, right? What if some people criminalize bestiality because they think it's immoral, and some do it for animal rights? Under Kennedy's approach, if it's some good, some bad, you still strike it down. Because in the Romer case, some people voted for it because they want to preserve morality. Other people did because they hated gays. You have this mixed motive. And in the Kennedy world, mixed motive means you strike it down. So even then, right? If you think that having sex with a horse is immoral, period, I don't care if the horse consents or what. And there's some people who say, no, think of the animal. You have different motives. I'm moving faster than I like to because I want to finish today. Justice Thomas's dissent cites Justice Stewart and Griswold. He calls this a, quote, uncommonly silly law. And Thomas says, were I a member of the legislature, I would vote to repeal it. This is a waste of resources. But Thomas rejects this right of privacy. It's not in the Constitution. There's no dignity clause. I can't do this. So the court invalidates it. Okay. I did that last one quicker than I wanted to, but I want to finish Windsor in time. So questions on Thomas or Scalia dissent? I mean, the Scalia dissent mostly speaks for itself. He leaves, unlike Kennedy, he leaves much to the imagination to think, what does this mean? Scalia tells you precisely what he means. There's no doubt about it. Questions on Scalia or Thomas? Yeah.
Do you think that Scalia may have sort of been kind of hinting at that sexual orientation should be a higher scrutiny level that it should receive?
Do you think he thought it should be?
Well, the way I read his dissent, 75% could have been a concurrence, and 25% he just
Really?
doesn't agree with.
Never heard that before. You think so?
Yeah, because it seemed like he was saying, "Why are you applying rational basis and not simply saying that this is?"
Oh, I think he's being sarcastic.
Well, no, I understand.
Oh,
that.
no.
That's-
No. He. John's laughing at me. I think he's being sarcastic, saying, "Listen, if you think this, then you have to do strict scrutiny." I don't think he accepts the predicates. He's basically laying out what he thinks a intellectually honest opinion would look like. Like, if you actually think these things, you have to do strict scrutiny. I don't think he was concurring. I think he would vigorously dissent. Yeah, he
Right.
dropped the mic in this one. This was not a.
So the 25% part that I understood is him just being, he doesn't agree with the end result. Had he been on the other
Had the
side,
court, okay, let me answer your question this way. Had the court held that strict scrutiny was appropriate, he would have still dissented.
Right.
Think of his VMI opinion, right? Where he dissented in the Virginia case, saying that intermediate scrutiny was not really appropriate for this institution. So he was still dissented. There's no concurring on this one. Not happening. All right. Let's move on to Windsor in my remaining few minutes. Our class on Thursday we've been more jam-packed, so I can't stretch this one over. I wish I could do a full class on just Windsor, but it kills me. I don't have enough time. So again, the Defense of Marriage Act was passed in 1996, signed into law by President Clinton, and had two main parts. First, it said states were not required to recognize foreign same-sex marriages. And second, for purposes of federal law, marriage was defined as a union of one man and one woman. So you've not been exposed to most federal laws, right? But believe it or not, in thousands of places in the United States Code, it references a married person for Social Security benefits, veterans benefits, tax benefits, everything you could possibly imagine. Historically, how did the federal government determine if a person was married? They looked to the state. Usually it's a state where the person resides, right? The person's married in the state where they reside, they get federal benefits. So for example, imagine if, I'll make it up, Arkansas allows you to marry at 16 and Texas allows you to marry at 17. I'm making up numbers. What if a couple marries in Arkansas at 16 and they move to Texas? Texas would not recognize their marriage, and then they would not be married for purposes of federal law. Okay? There's not a mystery here, right? The fear was, though, that people would start getting married in states that allow it and move back home. And then maybe they would claim to be married. So the way to resolve this sort of dispute is saying, listen, we're not going to look to the place where the marriage was celebrated. We're not going to look to the place where the married couple lives. All we're going to look to is a place of federal law. So in this sense, and Scalia makes this point, DOMA had a very practical purpose. A very practical purpose. A single standard nationwide for federal law, right? I'll get to the other stuff in a minute, but for purposes of actual law, a single standard nationwide. Okay, so actually let me ask Samuel this question. DOMA also made clear that this law was premised on moral disapproval, right? They said, we disapprove of gay marriage, we think it's wrong. They also said, we have this legitimate purpose of standardizing federal law. So what do we do with the statute? That part of the history of standardizing federal law is perfectly legitimate, and part of it is saying we deem that morally reprehensible. It's wrong. How do we treat that then?
Kenny would go with that part of it's out of animosity.
Okay. And this is the key to understanding the DOMA case, the Windsor case. Part of the law, indeed a huge part of the law, was making federal law more efficient. Okay, this is not particularly controversial. The federal government defines terms all the time. I'll give you an easy example. The federal government defines a person to include a corporation. Under RFRA, the Religious Freedom Restoration Act, it says it applies to a person. Under the Dictionary Act, a person is defined to include a corporation. Congress defined stuff. This is not particularly controversial. So part of it was merely a matter of administration of the law and making it standardized. But here, the history of the law made clear that this was premised on moral disapproval of homosexuality and homosexual marriage. The law is even called the Defense of Marriage Act. Like defending it from what? Well, defending it from gay marriage, right? They thought this would demean the institution. So how do we deal with this, right? Where we have some good motivations, standardizing federal law, and we have some perhaps motivations the court doesn't like, which is, moral disapproval. The court does, as Samuel mentioned a moment ago, what Justice Kennedy's want to do. If this demeans a person, if it takes away their dignity, even if the state has a good reason for doing it, the law does not stand. Okay? So the case itself, here's more, I forgot to show some pictures of Lawrence and Garner. Okay. This is actually Edie Windsor. So the facts of this case are this. Windsor lived in New York with her then girlfriend, Thea Spire. And in 2003, they went to Canada to get married. Shortly thereafter, Thea Spire passed away. Under federal law, if your spouse dies and you get an inheritance, it doesn't get taxed. You basically get this huge tax benefit. Because they were not married under federal law, she paid the entire tax. Then Windsor sued the federal government for a tax refund. This entire case was about a tax refund, which is stunning when you think about it, but that's what this case was about. That's what they got into federal court. Now what happened next is somewhat surreal. After the lawsuit was filed, the Attorney General, General Holder, announced that the federal government would not defend the constitutionality of DOMA. This was unprecedented. So it's happened before that an Attorney General has not defended the law's constitutionality. But this has only happened after a court struck it down. What happened here was that the administration decided on its own accord that under heightened scrutiny, which the court had never held, but under heightened scrutiny, DOMA cannot stand. So I actually don't have any objection to the president having his own constitutional law. I have no objection to that whatsoever. But the surreal part was this. Even though the Obama administration said this law was unconstitutional, it continued to enforce it. You can't have it both ways, right? If the law is unconstitutional, you stop enforcing it. If it's valid, you enforce it. Does anyone want to guess the reason why he continued to enforce the law? There's a very strategic reason why.
Congress?
No. Nothing to do with Congress.
So it would be challenged?
Had President Obama issued Edie Windsor a check, it would have never gone to the Supreme Court. Had they dismissed the case, it would have never gone to the Supreme Court. This was done, and this is not a mystery. The president said it was unconstitutional and then didn't defend it, but enforced it to get a Supreme Court decision out of it. Not that Congress could repeal it. I mean, you're right about that, Mirza. Congress could repeal it, but they wanted a Supreme Court case in this. I'll take it one step further. The Second Circuit Court of Appeals ruled in favor of Windsor. In other words, the government lost. The government agreed with that position. They appealed the case to the Supreme Court even though they didn't agree with the appeal. They appealed it for the sole purpose of getting the justice to decide this case. I'm sorry. I love procedure. I love procedure. This is procedurally screwed up. This is wrong on many levels. Forgetting the substance, but you don't appeal a decision you agree with just to get to the Supreme Court. Bad. Bad, bad, bad. In fact, the parts of the opinion that were cut out of your book were all about whether they were standing. And you didn't have to read those, but I don't think this case even had standing. I think it should be dismissed outright. But procedure doesn't matter to Justice Kennedy. It's relevant. Whatever. Like shrug emoticon, right? Whatever. So the posture of this case is screwed up. But in any event, the court finds that they're standing. What actually ends up happening is that the House of Representatives has a lawyer who argues to defend the law the president wrote. These are crazy times. So they're standing, blah, blah, blah. We get to that. So again, I've asked this question, I think, 3 times today. If you were a lawyer, this is actually Robbie Kaplan, the lawyer for Edie Windsor. If you're a lawyer for Robbie Kaplan, you say, wait a minute, how do we argue this case? We say, well, this is a suspect class, so strict scrutiny, right? Suspect class, strict scrutiny. We have Lawrence, right? We don't have Bowers anymore. Let's just go and say strict scrutiny. Does Justice Kennedy so hold? No. No, he does not. People are waiting for this. Just give us strict scrutiny or something. And the Justice Kennedy doesn't go there. Instead, he writes about dignity. He writes about dignity. When states, 12 of them, legalize gay marriage, or actually at this point, I think there were 12. Yeah, I might be off by 1 or 2. But when the states at this point legalize gay marriage, it gives them dignity. DOMA, enacted many years earlier, retracts that dignity. By treating these people differently in light of federal law, you are demeaning them as people. And you're not just demeaning them. Who else are you demeaning? Their kids. And there were a number of amicus briefs, friends of the court briefs, explaining how DOMA harms the children of gay couples. And this tugs at Anthony Michael Kennedy, no relation to Anthony Michael Hall. This tug at Justice Kennedy's heartstrings very well, that they're discriminating not just against the parents, but of the children. So what's the test here, right? I'm going to give you the test, okay? The court has to address whether the resulting injury and indignity is a deprivation of an essential part of the liberty protected by the Fifth Amendment. The court, the court now has to address whether the resulting injury and indignity is a deprivation of an essential part of the liberty protected by the Fifth Amendment. What is that? So, 2 brief notes, right? First of all, the Fifth Amendment has a due process clause, right? So there is substantive due process in terms of the federal government. The federal government, bound by the Fifth Amendment, cannot deprive you of fundamental rights. But the Fifth Amendment lacks equal protection clause. This was Bowling v. Sharp. So you basically have to reverse incorporate the equal protection clause into the Fifth Amendment. That's why he frames it in this manner. But does DOMA violate the due process clause or the Fifth Amendment? I'm sorry, does it violate due process or equal protection? We don't know. It probably does, but the reason why this falls is because it denies people their dignity, right? And it engages in an act that the federal government cannot do. DOMA, quote, injures the very class New York seeks to protect. And it's based on a bare desire to harm. Wait a minute, wasn't DOMA passed also to make uniform federal law? Kennedy said this is no longer enough. If the law evinces a bare desire to harm, it cannot stand. In fact, there was this great colloquy during arguments between Justice Kagan and Paul Clement arguing for the House. And Kagan goes, Mr. Clement, what if this law is based on moral disapproval? Does it survive? And Clement goes, this court has never before held that the mere fact that Congress passes a law based on moral disapproval, it can't stand. And Clement says, if you rule that way, that moral disapproval is no longer a valid basis, I lose. And he lost. So Windsor takes moral disapproval out of the playbook of the state. This is the crucial building block for gay marriage. Because the reason why gay marriage laws were passed was because people didn't approve of those unions. There's not a mystery here, right? The voters in various states said, we don't approve of those unions, we're going to prohibit them. Once you take out moral disapproval, which is what Windsor actually does, gay marriage is a hop, skip, and jump away. Again, this is the incrementalism we're talking about earlier. Okay. There's some discussion. Oh, by the way, the last sentence of Windsor, the very last sentence. This opinion and its holdings are confined to those lawful marriages. In other words, it only applies to marriages legalized by the state. Does anyone believe at this point? Does anyone believe it? I actually have in my notes. Does anyone believe this? And I put in parentheses 2013. And I add another line, 2015, after Bergville. Don't believe it, right? So these promises were never meant to be kept. So any questions in the Kennedy opinion? I rushed that way too quickly, but I think you got the gist, and we'll do more of it next class. Yeah, Heidi.
Can you just repeat the test one last time?
It's in the opinion. Hold on. Just scroll through my notes. The court now has to address whether the resulting injury and indignity is a deprivation of an essential part of the liberty protected by the Fifth Amendment. Yeah, Scotty?
I just had a question and some attorney dicta. What I was kind of curious of what he meant by this is a discrimination of an unusual character. Because I feel the state has had interest in.
Okay, so what he's getting at there is because it's a federal law, right? He's saying usually domestic law is reserved for the states. The federal government does not get involved in federal laws. That was his point here, which led some people to hope, not me, but some people to hope that, you know, this was going to be a reason why states should be allowed to legalize or not legalize gay marriage because of federalism. But that was just a veneer. Indeed, that was the point of the Chief Justice saying, look, this is about federalism, and states can do whatever they want. Yeah, don't believe it. So that was the Chief's dissent. I have my notes, Scalia J dissenting bitterly. At this point, he's resigned to defeat, right? If you look at the progression, in Romer, you know, like the stages of grief. In Romer, he was in denial. In Lawrence, it was anger. I think he's come to terms. Actually, he came to terms in a Bergefell, but I think he's just he's sad now, whatever the penultimate stage is. He's just sad. This case is about power and the power of the people to govern themselves and the power of the court to pronounce the law. We have no power to decide this, and even if we did, we have no power to invalidate this decision. You know, he, again, skewers the court. It's not a concurring opinion, saying, pick a tier of scrutiny for crying out loud. Give us a fundamental right. Do something that actually fits with constitutional law. Enough with this dignity stuff. But again, Kennedy has never once replied to a single thing Scalia ever wrote in this case. It's utterly and totally irrelevant. Scrutiny doesn't matter. What is the test? The liberty of the person. There's really nothing there. Okay. Any question on this Scalia? I don't mean to rush through it, but again, we've already basically, he repeats himself after a point, and I only have 2 minutes left. So any questions on the Scalia? Yeah.
So is it not correct to say that Lawrence took away the moral disapproval grounds?
Lawrence hinted at it. Windsor made it really clear.
But this only applies to Congress.
Oh, but the due process clause applies to both branches of government. Come Windsor, Bergefell next class, I'll take it away for everyone. Right, so first they came for moral disapproval, they took it from Congress, and they were silent. And then they came and took away from the states, right? Neither branch has it anymore. Okay? Anything else I want to say? And Justice Alito has a similar concurring opinion. I wish I had more time for this, but I really don't. I can take questions later, but unless there's anything else. All right, have a wonderful day. Make sure you do the reading for Thursday. It's going to be a packed day.